Well, thanks very much, Guillaume. Two things. First of all, I'm going to apologise because I'm speaking in English, and unlike Maurizio, I'm not even able to drop in the odd word of Italian into this talk. And the second thing I'd like to say is there is a paper. It's not my intention to read it. I will talk about the things that are in that, but if you want to read it at some stage, then maybe you can get an extra point for doing that as well later on. Now, what I'm going to talk about, as Guillermo explained, I hope, is the issues arising from disposal of cargo. And in order to do that, we need to consider, first of all, what are the owner's duties in respect of cargo, because it's only by establishing the parameters of those duties that one can go on to consider how to deal with liabilities and costs that might arise out of a wreck removal operation. So the primary duties that we'll look at come out of the bill of lading. We'll then look at what duties or obligations the owners tend to take under wreck removal contracts. We'll look at then conversion and how to deal with abandonment, and then various options that there might be or might not, as we'll discover when we come to look at options for recovery. So that's the outline. Owners' duties under the bill of lading contracts. There are, of course, other issues, but the primary duty on the owners is to look after the cargo and deliver it to the discharge place. Now, those duties arise under the bill of lading if the ship owner has issued the bill of lading in his name, and it will provide for that. And if he doesn't deliver the cargo in accordance with that contract, he'll be liable for loss and damage to make the cargo good. That's fine. He may also, as you know, be able to rely upon various defences within the bill of lading contract, such as Hague-Visby rules and the like. And for this sort of incident, we're probably talking about area navigation type defences, possibly due diligence, unseaworthiness at the outset of the voyage. So there are a number of defences available to the ship owner within the bill of lading contract. I'm not going to talk about those here. That's not what I'm concentrating on. Even if he's not the contractual carrier, under English law, he still has a duty to cargo interests. Okay, I'm sorry guys, for those at the back who weren't hearing me. Maybe that's better. I won't shout. For those ship owners who haven't issued bills of lading, but the cargo is nevertheless carried on board, they still owe the duty of care to those cargo interests by virtue of their possession. And under English law, we refer to that as bailment. It's similar in many ways to negligence, except for the fact that the courts will seek to imply terms into the bailment. So rather than just having a standard duty of care and negligence, they will look at what terms the owners have accepted the cargo, and those terms would usually be deemed to incorporate Hague-Visby type defences, particularly if they were in the relevant charter parties. So even though if the claims were brought direct against the ship owner in bailment, he can probably rely on Hague-Visby, but he still has a duty to look after the cargo and deliver it to the ship owner. So, wreck removal. Consider then the position when the ship gets into difficulty. Might have capsized in a harbour perhaps, might have been some serious grounding leading to cargo flooding. It may be that ship owners have engaged salvors on salvage terms to start with. That's not gone wrong, they've agreed to get out of it for whatever reason, and they're now looking at a wreck removal contract. Now there are two other ways that could come into being, of course. They could enter into wreck removal immediately, or indeed many authorities around the world have the power to order the ship owners to remove the wreck or the casualty, usually if there's a danger to navigation or if there's a danger to the environment. And the authorities will then issue an order requiring the ship owner to take steps within a certain time, and if they don't take those steps, then the authorities can themselves take those steps and recover the costs from the ship owner. It's usual, but not always, it would be usual for the ship owner to take those steps, and the P&I Club will often take over the negotiating of that, and we'll look at that in a moment. But not always, not always. And one recent casualty in the North Sea, for example, the ship owners have abandoned the wreck, including the cargo that's on board, to the authorities and said, we're not dealing with it, you go ahead and deal with it. And the P&I Club has acquiesced in that, and there are reasons for them doing that, which we need to go into here. Nevertheless, that's the basis of it. So let's assume for these purposes, though, that it's a standard type issue, and the P&I Club is supporting the owner, and they will seek to enter into a wreck removal contract. It's sometimes bespoke, a sort of handwritten one, but less so. More often than not, the parties would seek to use one of the standard form contracts, typically a BIMCO, either wreck stage or wreck hire contract, often with some additional clauses, sometimes quite complex additional clauses. But that's the basis upon which the wreck hire contracts will come into being. It's important then to look at what those forms provide for, and the ship owners are the party to the wreck hire or wreck stage, as it may be. It's not the club, it's the ship owners who are going to contract to do this. Sometimes it may be the club, but we'll examine that. It's not the club, though, it's the ship owners who are the party. And the club will provide security, and the club may end up paying for that wreck removal contract, but that's because they insure the ship owner's liability. They don't have to do that, and it's a pay to be paid. Hence the provision within the wreck hire that the club will provide security to the contractors for those wreck costs. And the key point here to remember, of course, is what is it that they're contracting to be removed? Well, it's the vessel. That's the phrase that's used in the BIMCO terms, and we see there, though, that vessel is a defined term, and in clause 2, definitions of either wreck hire or wreck stage, vessel is defined as any vessel, craft, property, or part thereof, of whatsoever nature, including anything contained therein or thereon, such as, but not limited to, cargo and bunkers, as described in box 4. So when the ship owner contracts under a wreck form, he is contracting with the salvor or contractor to get rid of the cargo, to lift the cargo as well. That's what he's saying he's going to do, providing it's described in box 4. Box 4, if you're familiar with these forms, is the front of the contract where you set out a description of the ship, and there is a space there for description of the cargo and the type and nature of the cargo. So it includes the removal of the cargo. That's what he's contracting to do at this stage. Now, it's usual or often that some cargo might actually have spilled, and particularly with container ships, some cargo will have spilled. It is no longer therein or thereon. The ship is just lying round about it somewhere. But nevertheless, it is also usual then for the contract to provide for debris removal in and around the area, and there are a number of reasons for this. During the actual wreck removal operation, some bits may fall off. That's just part of the operational hazard of that. And so you want to provide that the contractor is going to remove those bits that have fallen off the ship even before they've done so. So that would be something to include within the wreck hire form. And it would be defined by both field, the area that one's looking at, and also by size of the piece that can be left behind. And clearly, with containers and the like, you'd want to remove those. They'd be a hazard to the hazard to navigation. So you want to get rid of that, and I say it will or must include cargo. Usually, if a casualty has happened within a port area, the port authorities will require this debris to be removed, and the debris that they require to be removed will be the cargo that's fallen off it, as well as bits of the ship, of course. Now, just because it's been under the water doesn't mean to say that cargo's got no value. You can think of any number of precious metals, of course, which retain their value simply because they've been submerged. And so you can't just abandon them in that sense. They have a value to somebody, and the ship owner, of course, is liable for that loss if he just leaves them behind for the full amount. And as his P&I Club, they will pay him for that. It's in the P&I Club's interest to try and minimise those losses as far as possible. So if it's got value, it's got liabilities. Just want to touch then on cargo and abandonment. It's highly likely that in the case of a ship sinking, that cargo will seek to abandon their cargo to underwriters. Now, that doesn't mean necessarily that there has been an abandonment of the cargo. Certainly that's not an abandonment of the cargo to the owners, to the ship owners. It is simply an abandonment to the underwriters under the policy where they seek to recover either for an ATL or a CTL under the policy. And the other thing to remember is it's not even an abandonment to the underwriters really, in the sense that the underwriters probably will not accept that abandonment. Because if they do accept the abandonment, they then take over the liabilities and responsibilities for the property, something they won't want to do, because they would then be responsible for any pollution that arises out of that. So the usual rule is that the cargo underwriters, the cargo abandons to underwriters, the underwriters choose not to accept, but still nevertheless pay out under the policy. And the effect of that is that title remains with cargo owners, it remains with them. Nobody has yet abandoned anything to the ship owners. And so from the ship owner's point of view, the fact that there's stuff going on between the cargo underwriters and the cargo owners is neither here nor there. There's been no abandonment to the ship owner. And if the cargo has not been abandoned to the ship owner, he's still liable to the cargo interest to deliver it and to deal with it in a manner that's appropriate to the cargo. It's not what we use. It's not res nullius. Res nullius is where the cargo is nothing. It's not owned by anybody. It has been truly abandoned. And the history, the legal history under English law of some of these cases is quite interesting. I highlight one in my talk in the paper, whereby a cargo of gold bullion, and these cases often hinge on these sort of cargoes, which was sunk on a ship during the Second World War, was being recovered some 62 years later, and the finders of the gold bullion sought to say it was res nullius, it had no ownership, therefore it was theirs. And the court held that no, it remained with the underwriters in that case, that it had been abandoned to them. It remained with the underwriters, they paid for it, they'd accepted it. The fact that they hadn't done anything about it for 62 years was neither here nor there. They were simply waiting for the opportunity and technology to advance so that it could be recovered for them. So time is not an issue either. One needs to be careful about time. So it seems to me that owners could abandon the vessel or the voyage. Owners could do that. They could say to cargo, actually, we're out of here. It's nothing to do with us. We're fed up with it. We just leave it. And indeed, on that case in the North Sea, that's exactly what they've done. There would still be a liability against the owners because the authorities will then remove it and then sue the owners for the costs in doing so. And in that particular case that I mentioned, the ship owners have provided for a limitation fund in a particular jurisdiction to deal with those issues. So that's the way that would work there. So, just checking on time, getting towards the end. I'm fine. The disposal of cargo. So if cargo is not in back, if cargo has not been abandoned, and the owners have got a duty of delivery, but nevertheless they go ahead and dispose of it, and they can either dispose of it themselves, or they might dispose of it under the rep contract, because under the rep contract there's an option to hand over everything to the contractor, or to take delivery of it themselves. So if they dispose of it under the rep contract and give it to the contractor and say, you have it, whatever you get out of it is yours, which is the easiest way of dealing with it, sort of wash their hands of cargo, then they will be liable for the tort of conversion. Now under English law, the tort of conversion is where you assert a positive or wrongful act with the goods with a manner that's inconsistent with the owner's rights. Now the owner of the goods in these days, he's got goods, they have value, he wants those goods. He doesn't want a pile of cash. If you take the goods and turn them into a pile of cash, you might have given him the cash value, but you haven't given him the goods, and he wants the goods. So you've converted it from something that he wanted into something that he didn't. And so you can be liable for the tort of conversion in that sense, the full amount. And if you've given that to the contractors under the rec hire contract, then they've got the benefit of the sale, but you've got the liability because you should never have entered into that contract. So you need to be very careful about that sort of agreement at the outset when entering into rec removal contracts. So just to recap then on rep contract obligations. Under the contract, other than the providing delivery to the contractors I just mentioned, the contract will generally provide that there should be delivery to the owners, as the ship owners, and that will be delivery of the vessel, which we saw at the beginning included cargo. So the contract will provide where that delivery of cargo will take place. Usually it will be alongside a quay or on the quay, so the contractor will either bring it to a quay or put it onto the quay. Thereafter then, it's the owner's responsibility, the ship owner, because he's contracted under the rec hire contract. So that means that the owner needs to provide for storage costs. He needs to have engaged the terminal and provided space for storage and pay for that storage costs. And if the cargo then don't come and turn up and pick up their cargo, those storage costs will mount up, and that's owner's direct liability. And if you try to get rid of it, if you just sold it, then obviously you're liable for conversion. So how do you avoid that? Well, there are a number of ways. Obtain evidence of abandonment. Because if you can show that the owners of the cargo have in fact abandoned the goods, then obviously they're yours and you can deal with them as you like. Ways in which to do that: you can write to cargo. You write to all the cargo interests and you tell them, we're engaging contractors, we're going to deliver your cargo at this place. Please confirm that you will come and take them. Alternatively, if we don't hear from you, we will treat that failure to respond as an abandonment of the cargo to us, and we'll then deal with the cargo appropriately. Provide a time limit in that letter. Now, the letter itself does not create the right. It doesn't create an abandonment because they might not respond for any reasons. You can't force that on someone. But nevertheless, it is evidence that you could subsequently use if sued, which might work in your favour. You can seek a court order. You can go straight to court to do that and get a court order saying, I've not had any response, I want to sell the cargo. If it's a cargo that's deteriorating, it's very easy to get that because otherwise the cargo would be valueless. But if it's a standard cargo which isn't deteriorating, then the court will need to look at how long it's been, what steps you've taken to contact the cargo, and again, that letter is useful evidence. And the third way of dealing with the cargo is take a risk. Just sell it. And there's nothing wrong with taking a risk if you've evaluated it properly. If you think this cargo is worthless, nobody's going to be bothered with it, I'm going to sell it anyway. To hell with it. That's a perfectly acceptable, commercial and indeed legal approach to this sort of issue. So long as you're evaluating your risks correctly, selling it all might be fine. So I don't have any particular problem with doing that either. Last point, if I've got 5 to 7 minutes, thank you, I should speak particularly slowly. The can owners recover? Difficult, I think, is the short answer in these terms. Salvage. It might be salvage. If there was a salvage contract, then obviously that is salvage, and the parties will be responsible for that. Indeed, owners could enter into a lump sum salvage contract and salve the cargo and claim monies back in general average if the voyage is completed. That's not a problem with that at all. Frequently happens. But under a rec contract, much more difficult because the ship owner is probably not a volunteer, perhaps. Certainly the contractors have just paid the ship owners for that. So that creates certain difficulties in relation to salvage. So the salvor has entered into a contract where he's been paid. P&I club. Those are possibilities where the P&I club can enter into agreements themselves, where the P&I club can pay, because they might well be parties they're a non-interested party in that sense, because the P&I Club is only a pay-to-be-paid individual, so they rely on the ship owner. So in that sense, they've got no interest. So maybe the P&I Club can pay for something and then seek to recover it on some form of basis. In GA, GA is a possibility, but it does require the voyage to be complete. So if this incident was just happening somewhere else and the ship was left behind and was a wreck, then obviously that's not GA. But if the ship was refloated and then towed somewhere and all the cargo was taken out, that seems to me that even if that was done under a wreck removal contract, that would be a cost that could fall into general average. And the key there is whether or not the money has been expended for the common interest. So there has to be some benefit to all the interests, or at least the common interest, which would be cargo and ship. If it is just for the benefit of one party, either for ship or just for cargo, then it's not general average. One point on salvage, which is in my note, it might be possible for the ship owners themselves to abandon the ship, abandon the voyage, leave, I'm out of here, but then come back and carry out the wreck removal contract as salvors. There are any number of cases where people act outside of their obligations where they get a reward. So a pilot, for example, that is engaged to bring the ship into a port, but then something happens that he uses his services to assist the owners, would be entitled to a salvage reward, because that was something over and above what he was contracted to do. And there are a number of towage cases the same. The same sort of thing seems to apply possibly for ship owners. But finally, in relation to all of that, I have to say that cargo just may not pay. Of course, you need to get security, which you might have, but in other words, they might anyway assert that owners were liable under the bill of lading, that their defences weren't available to them. So in those circumstances, they would no longer have to pay, and it brings us effectively back to where we were right at the beginning of the talk. So I think I've covered everything there, other than questions. So thank you very much for listening.